Good evening, everyone. I hope everyone is okay. I wanted to thank everyone for my last minute class last week. I was going to try to do it while I was abroad, but I was concerned that maybe I wouldn't have good connection and just figured it would be better just to put everything online. Um, but child custody is kind of important. So I'm going to highlight some of the things. I'm going to go over what was uploaded on for module 3 today because the visitation is kind of a short module. So I'm going to hit the hot spots on child custody. And as always, if you guys have questions, especially regarding last week's upload, please do not hesitate to reach out to me in any way, shape, or form. The opening page should have my business cell, so you guys are always welcome to reach out to me. I have no problems if you guys text or call me. Obviously, if I'm in court or in a meeting, I'm not going to be able to respond, but please, you guys are welcome to reach out to me in any way, shape, or form. So let me take roll call now. Jacqueline? Jacqueline?
Yes, I'm here. Sorry.
Okay, thank you. Oh, this is Jacqueline Ailman. Yes, I see Jacqueline. Okay, perfect.
Here, yeah, I'm here.
Thank you. Yolanda?
Here.
Thank you, Yolanda. Melissa?
Present, Professor.
Thank you. Chow?
Here.
Thank you, Chow. Ariana? Ariana? I see you, Ariana.
I'm here, sorry.
There you are. Thank
I'm
you.
here, apologies.
Okay, perfect. Jocelyn?
Here.
Thanks, Jocelyn. Myra? Myra? Brianna? Brianna?
Here.
Thank you, Brianna. Sergio? Sergio? Alondra, I know you're here. Jesse? Jesse. Carolyn?
Here.
Thank you. Sandra?
Here.
Thank you. Gary?
Here.
Thank you. Helena? Helena?
Montgomery, yes, I'm here.
Thank you so much. Bridiana?
Here.
Thank you. Am I saying that correctly?
Yes.
Perfect. Okay.
Mhm.
Brenda?
I'm here.
Thank you, Brenda. Tara? Tara?
I'm here and I didn't receive an upload for something. The only thing I have is the PowerPoint and the reading. Was that it?
For week 3, yes, there was a reading and there were PowerPoints and an outline. Did you see that?
I believe I have the outline too. Thank you.
Okay, perfect. Thanks, Tara. Carla? Carla? Paula? I'm sorry, was somebody speaking? Sergio, was that you? Okay.
Sorry, Professor.
I,
Want to make sure that I'm present.
yes, I will mark you as present now. Thanks, Sergio. Appreciate it.
You.
Isaac?
Here.
Thank you. Maria? Maria? Jessica? Jessica? Jacqueline, you already said you were here. Okay, thank you, Jacqueline. I see you. Elena,
Here.
thank you, Elena. Brittany,
Here.
thank you, Brittany. And Leslie. And then if anyone has come in late, just shoot me a chat in the messages, and then I will mark you guys off or just during the class if you guys come in late. Obviously, you guys are not here if you're coming in late, but just let me know. Okay, so I wanted to go over child custody just from last week, and I'm going to make this really brief because I know we have a whole other visitation section that we're going to go over today, but just because custody is very important. It doesn't come up in all family law cases because obviously not everybody who is married or has a partnership have children, but I find that child custody, in my practice at least, can be the most contentious area of the law. And that is because unlike a lot of the other issues, such as like financial issues, um, child custody can be very gray. And I find that in my practice and in the cases I handle, judges can have very different views as to, what is in the quote unquote best interest of the children, which is a phrase you hear a lot in family law. So, what is the best interest of a child? And what I may think is in the best interest of a child, and what an opposing counsel may think is in the best interest of a child, and what a evaluator may think is in the best interest of the child, and ultimately what the judge may think is in the best interest of the child can be wildly, wildly divergent. So I find child custody to probably be the stickiest part of family law, because again, there's no real bright line test as far as I'm concerned. And there can be so many different issues, and there's usually a lot of it can get very nasty with cross allegations between parents. So again, I find child custody to probably be I don't think hard's the right word, but just the most difficult part of family law. So again, I just want to go over this briefly since this was just uploaded, but I want to kind of go through the highlights of custody. And again, it doesn't come up in all cases, but these cases, in my opinion, can be the cases that can really put people through the ringer. You can be in court for literally years and spend just an obscene amount of money when child custody issues are at issue. So I think this PowerPoint says the same thing. It says there's tension, anxiety, hostility, volatility. That is all absolutely true. It is just it can just get very, very ugly and very emotionally, and understandably so, because especially in the case where one party may think that the other party is not looking out in the best interest of the child, or even worse, that there may be some sort of allegation of abuse or neglect. Again, it can get just very, very emotional and just very, very nasty. And there are some people in family law who try to focus just on child custody disputes. There are other practitioners who try to focus more on maybe high asset individuals. But I think, with family law, as we discussed in the first week, there's so many different aspects of it. But there are certain professionals who are really good at dealing with child custody. There's also minors counsel, where a counsel just acts as an attorney for the minor, and they get to advocate for what their client wants. So there's a lot of different moving parts when child custody is involved. So, okay. When you start an action, you can start by asking almost immediately for some sort of custody orders. So as the slide states, the parties can decide to request a request for order or an ex parte. So a request for order is basically the form that is used in all family law matters when a practitioner or a litigant wants the court to do something. There's also contempt actions and some other less common forms, but the request for order, and that's shortened for RFO, is pretty much the starting point of any time you go into court to want something. So you could ask for an RFO for support, RFO for attorney's fees, and RFO for custody. So if you want to, if there's nothing really pressing, meaning nobody's making allegations against the other that the child is in jeopardy, or somebody's about to kidnap a child, nothing of an urgent matter, then most people will just start the petition, meaning I want the divorce, and then also file a companion request for order saying, hey, while this matter is pending with the court, we need some temporary orders regarding custody. And that's especially important if it's litigious and the parties can't get along and the communication skills aren't that great, so that there is a piece of paper that is signed by a judge saying these are your orders, so that it's very clear cut and each parent knows when they are supposed to exercise time or exercise legal or physical custody of the child or children. You can also go in ex parte, and ex parte basically means emergency. And there are cases where you may need to go into court on an emergency basis for custody. I'll give you a real life example. So I had a case where I represented husband. Mom had essentially just left one day. He didn't know where she went. He started looking around, realized the children's passports were missing. So we had to go in on an emergency basis, basically saying, hey, we have no idea what happened to mom. She has the children's passports. We are concerned that she may leave the country, or we don't know what is going on. So in situations like that, you can say, hey, court, this is an emergency. We don't know where the child is. We need an emergency order. Similarly, if, God forbid, there's some sort of allegation of abuse and one party is abusing the child, then you can go in ex parte and say, hey, listen, we need to put in some orders now. Most likely in that scenario, if it's an emergency, you're going to be asking for temporary sole, physical legal custody. But you can also ask for, I guess, temporary emergency ex parte visitation. Did somebody have a question?
Yes, ma'am. I have a question. So, is ex parte only used for emergency purposes only, or is it once? Because I was taught that it was one-sided, where you don't have to get the approval from the other party to get the file the ex parte.
So ex partes are supposed to be for emergencies only. You can also use an ex parte to what's called shorten time, meaning for whatever reason, if you don't want to wait, because in most instances, if you file anything, especially in Orange County, on a regular RFO, it's going to be a 2 to 3 month outset. So let's not say it's like a true emergency where literally somebody absconds with a child. You can say, okay, I don't need to hear this. I don't need you, judge, to hear this today or tomorrow, but I cannot wait 2 to 3 months. Insofar as I think you're talking about notice, and I'm sorry, who is asking the question?
Gary.
Oh, thanks, Gary. So Gary, it's sometimes if you feel that giving notice to the other side will actually make the situation worse, then you don't have to give notice. But in most instances, you have to give notice to the other side 10 a.m. the day prior that you're going to go in ex parte. And again, ex partes don't have to be for just custody issues. It can be for any issue that the court has jurisdiction over. So it's very rare you go in for an emergency like support order. But you can, and there are other instances where somebody finds out, oh my gosh, I found out that, my spouse has put the house up for sale. It's about to go into escrow and I never knew about it. So there's financial ex partes as well. And again, you're supposed to give notice. Domestic violence, which kind of falls under the ex parte procedures as well, that too, you have an option of giving notice or not giving notice. Again, especially if you feel like in a domestic violence situation, if you give notice to the other side, then they're going to do something, again, let's say you can tell the court, if I give my spouse ex parte notice of my domestic violence or my request for custody, I think that spouse is going to abscond with the kids. And in situations like that, then the judge will make a decision like, okay, you're right. I don't think you had to have given notice, or the judge may say, no, I don't agree with you. You should have given notice. So I'm going to set this for another day so you can give notice. So it's really fact specific, but yes, there are instances when you don't have to give notice and you can go in unilaterally. And here in Orange County, the way they do it, and every county is different. What we do is we file our ex partes as an attorney online through the online portal, and then the judge's department will get back to you with some sort of decision, usually by email. And they do keep changing the process in Orange County. It used to be you had to come in person, basically sit there and wait, at least until the morning break, until the judge made a decision. Sometimes you were stuck there all day because, courts get busy. Does that answer your question, Gary?
Yes, ma'am. Thank you so much.
Okay. Oh, of course. Thank you for your question. I appreciate it. Okay. All right. So, in Orange County and actually in the entire state of California, if custody is at issue, you have to go through court mandated mediation. So every county is a little different. Orange County is once considered a non-reporting county, meaning if the parties go to mediation and they can't come to an agreement, the mediator is not going to make a recommendation to the court. There are other counties that are different. San Diego is a reporting county. Riverside is a reporting county. I don't remember if San Bernardino is or not, but in the counties that report, the mediator will meet with the parents, sometimes with the children, depending on the situation, and they'll issue a report and say, okay, the parties couldn't agree, but this is what I think the custody arrangement should be. So you have to go through that process. And if you don't go, if one party goes but somebody else doesn't, then the judge will usually kick it back until the people go through mediation. And the mediation is something through Family Court Services, meaning this is a mediator, social worker that is an employee of the county. And so in Orange County, I think they're still doing those remotely. You don't have to come in person. So, they'll set you up and then the mediator will talk to you. And in Orange County, most of the times the attorneys, even if you're represented, don't go. It's just the parties. And from the feedback I get from my clients, pretty much the mediator will know if you're close or not close. And if it's too far apart, they'll just say, okay, you guys go to the judge, and the judge will ultimately make a decision. In those counties where they report, meaning they do a report, my experience has been 90% of the time, even if a party doesn't agree with what the mediator is recommending, the judge is going to rubber stamp them. There's always exceptions to the rule. And you can always, subpoena the mediator to come, depending on how important this, the issue is. But I have found in my practice, most judges, whatever the mediator recommends, they're going to rubber stamp it. If a child custody case is particularly nasty, the court also has the option of appointing what is called a 730 custody evaluator. So these are doctors, individuals with PhDs. They will go much more in depth with the family. They'll make collateral contacts, meaning they'll reach out to the children's teachers if they're in school, physicians, anyone else that the parents want. to be contacted, and they give MMPI tests. I mean, it is very, very intrusive, and it takes a long time to prepare these reports, and it's very, very thorough. So if it's, again, particularly contentious, sometimes the parties and the attorneys can agree because we understand, hey, there's a lot of he said, she said allegations. We as attorneys aren't going to know, and the judge isn't going to know. So we say, okay, let's just agree to a 7:30 custody evaluator. This evaluator will really go in depth and detail. This is in their bailiwick, and then they'll prepare a report and present that to the judge. And usually in those circumstances, and I know in my practice, if there's a 7:30 custody evaluation, there's going to be ultimately what's called an evidentiary hearing, meaning I'm not just going to accept the report, especially if it's not favorable to my client. It will be a full trial where the evaluator testifies, each party testifies. If there are third parties, they'll testify. And again, these evaluations are expensive. They're very time consuming. You know, I think it's changing a little, but it's been my experience with most of these evaluations. They try to kind of, split the baby and maybe not say, okay, we agree that one parent is being really horrible. They try to make it more like 50-50. And I don't necessarily agree that that's always the best case scenario in all situations. But I think they try to kind of bridge that gap. But I've been in many cases with 7:30 custody evaluations. It is very invasive. They really get into a lot of private details. They put you under a microscope. I don't think it's a pleasant experience, but sometimes it is necessary, especially in cases where there's just a lot of cross allegations of, pretty heinous things. And I think we talked about this briefly. There is sometimes an overlay between family law and juvenile court. And it says here, in the event of a conflict of juvenile or dependency and family law court, the juvenile court will take precedent in making a determination of custody.
Professor, were you supposed to display the slides, or do we have to put
Oh
that?
my goodness. Thank you so much. Holy cow. I thought that was up the whole time. Bear with me. Oh my goodness. Hang on. Do you guys see it?
Yes.
It says 2 jurisdictional considerations. Okay. Thank you so much. Okay, yes. So yes, the juvenile court will take precedence, which is the same as dependency court. So if there's some issue of termination of parental rights because abuse or something has gotten so bad that the state is now considering terminating the parental rights of one or both parents, then the juvenile/dependency court will take superiority over the family law court. So Child Protective Services, they also get involved and they can provide reports. Again, if there's some sort of, well, I think all these calls are anonymous, and obviously they're also mandatory reporters. But when CPS gets involved, I know those cases sometimes that will trigger a 7:30 custody evaluation as well. If they find that, the situation is that grave, my experience has been, then they will usually tell that parent, hey, you need to go file a temporary restraining order, or you need to do something in order to protect your child. There are different reports that they can issue. They can find a substantiated report, meaning, hey, whatever the allegation is, we're substantiating that report, which obviously is not good for one parent or the other, in which they're substantiating it. There's inconclusive, meaning we can't figure out, what's going on with this case. There's not enough information or evidence one way or another for us to make any sort of recommendation. But in my experience, once CPS gets involved and, frankly, based on the finances of the parties, it will usually end up being a very, very expensive case with lots of different people within the child custody realm involved, not only including a 730 custody evaluator, but you can also have minors counsel appointed. There's then reunification therapists, conjoint therapists. I mean, this can really mushroom into a huge, huge thing. Jacqueline, did you have a question?
I just wanted to add that with the juvenile dependency courts, I personally have been going through with that, and took me 3 months long and lots of money to beat a case. And they just are really one-sided. They have the county attorneys, then they have the child's attorney, then there's your attorney, and then there's the father's attorney, all crammed in a real small courtroom that they don't usually like to follow what regular procedures are. And then with mediation in regular family court, the evidentiary rules are different than it is with a regular court. Most of the mediators aren't willing to accept any evidence at all from parties that aren't represented.
Yeah, I thank you for sharing that. I think I told you guys I don't do dependency termination only because what you're describing, Jacqueline, is my understanding as to the way things are done there. I guess from the court's perspective, they're trying to ensure that the children are safeguarded. That's their ultimate goal. But it seems to me that yeah, I haven't heard anything good from.
Unfortunately, they have a bunch of workers that aren't trained properly, that are overloaded on cases, and they might hear one side of the story and try to just go with it, and that might not be accurate at all. And then they're trying to do things without having the proper documentation. And with myself personally, I waived the time restriction for a speedy trial, and we had to do paternity court in juvenile dependency, and 3 months long of paternity hearings because I had to try and claim rights on my son. And so it's like it's worth it to take the time and to waive your right to be able to get the evidence shown that you need shown. That was the hardest 3 months of my life. I wish on my worst enemy. Sorry, I just thought I would share with you guys about that.
No, I hear you. Like I said, I've had clients come in who ultimately I will refer them out to, counsel who only focus in that area because as you mentioned, it almost seems like it's quasi-criminal. As you said, you have to waive time. I know a lot of the people that I meet with will say they feel pressured or they didn't understand the system. And it's almost quasi-criminal. And as you mentioned, it seems like people in that division are overworked. They don't have a lot of time to digest the information. And if your case is complicated in any way, shape, or form, they just don't have the resources to go through that. And it seems like there's just like a lot of turnover. So I'm sorry you had to go through that, but your experience kind of mirrors the people that have come into my office and explained to me what they have gone through.
Even just to find an attorney to represent someone in juvenile dependency is difficult because lots of the attorneys don't want to deal with it because it's so messy, especially when you have a child under 1 year old. They only give you like a year to get your case resolved, and then if you do reunification services, they only give you a year, and then otherwise they'll adopt your child out. So it's a real touchy topic that most attorneys don't want to be defense attorneys for juvenile dependency. And I wish anyone the best that has to go through something like that. I do advocacy work now for people, so.
Yeah, I mean, it's not fun. I'm one of those attorneys. I'm like, oh gosh, this seems like, family law is heartbreaking in and of itself. But every time I hear anyone going through dependency or, juvenile court,
Well, I had my son taken when he was 10 months old. I got him back when he was 12 months old, and I've had sole custody of him.
Oh, good.
The entire time, and all my kids I have full custody of. I work for a school district, and I'm definitely not somebody that's a child abuser, but it's definitely a hard system to try to work through when you're not guilty.
100%. And I think that's the same in family laws. And not that there's guilt in family law, but one of the frustrating parts as a practitioner, and I'm sure the litigants, and if you guys go into family law, and I hope you do, because I think it's a very important area of the law, you realize it's such a broken system. And as somebody who goes through a day, day in, day out, I often forget how hard it must be for people, because as a practitioner, I'm used to, like, we go into court, things get continued, you're looking at months here and there, and we're just kind of used to it. But, I sit back sometimes and think, gosh, if this were my case and I'm trying to get custody of my kids or whatever is happening, and the court is so backlogged, and I don't think, I
And
think most people are trying to do the best that they can, but
it's
it's
guilty before you
hard.
even have a chance to prove your innocence. There is no assumption
Right,
of innocence there.
right, right. Well, thank you for sharing, Jacqueline. And yeah, if you want to have a private conversation, I'll be happy to talk to you, because I know I feel for anyone who has to go through that system.
Yeah,
And
no,
luckily,
no, I'm good. This was now 17 years ago, but I still like it's such a serious
oh,
topic that people got to
I,
realize how corrupt and how bad that system is right there.
oh, yeah, it's broken. The system is definitely broken. Okay. Okay, let me get through this as quickly as possible. Although this is important, and visitation is all kind of dovetails into this, so I'm going to try to get through this as quickly as possible. So jurisdictional considerations, as you can see, and this is sharing now. Child custody is based upon the relationship of the state to the child, not to the parents. So I think this goes over this. Yes. So UCCJEA is a very important concept. When we first file for divorce, if there are children involved, one of the mandatory forms is what we shorthand call the UCCJEA form. And this is important because this is what grants the court the authority to make any sort of rulings regarding the children. And there are times when there may be dueling jurisdictions. For example, if I think we talked about this in our earlier class, but if parents are filing in two different counties or even two different states, and let's say for some bizarre reason they both happen to file at literally the same time, and each court is saying, well, I have jurisdiction over the children, the UCCJEA becomes very, very important. And there can even be like a little mini trial saying, okay, which court really does have jurisdiction over the children, which court can make decisions about the children. And if it's if it's pretty much in the beginning of a case and a court, so let's say, for example, in Orange County, let's say we know that there's an issue and the other parties, let's say in Texas, and we know that they're saying Texas courts have jurisdiction over the child. Oftentimes, the judges will literally get on the phone with one another and try to determine which court has jurisdiction. Sometimes this can go into a full-on hearing as well, but UCCJEA is a very, very important concept. And just practically speaking, it's one of the mandatory forms that we always prepare and file in any dissolution case or paternity case when children are involved and when custody or visitation are going to be involved. Some of these slides, I think, again, they're so esoteric and they're really not something that you deal with day in and day out. But UCCJEA, you'll definitely deal with on a pretty routine basis. This term is used all the time. Anytime the court makes any sort of temporary or permanent orders, they'll always have verbiage like, and the court has jurisdiction over UCCJEA. So this is a fairly important term and concept, and the courts take this very seriously because they don't want there to be two different courts making conflicting orders regarding child custody. So it's important that a court takes jurisdiction over the children. And if at some point we find out that there's dueling jurisdictions, the courts will work it out between themselves. I had a very interesting case early on in my career where Australia was also involved, so internationally. And so even in that situation, if they're a member of the Hague Convention, the judge in Orange County, called the judge in Australia. So even internationally, UCCJEA will be recognized, and depending on the country, they have reciprocity, and they'll try to figure out, okay, which country has jurisdiction to make decisions over the children. So this is the slide, and I already put this up, so it's on the module, but again, I'm just highlighting this because it is very important. It is routinely brought up, this acronym, and as I've told you guys, I'm not a big acronym, statute, all that stuff. I know where I need to go look, but UCCJEA, you will hear all the time. It's just a very, very important concept. So if nothing else, if and when you guys go work at a family law firm, you will be hearing this acronym and this term like throughout working at a law firm, either as paralegal or ultimately as an attorney, if that's what you want to do. But this is a very important concept, and you do need to know that those forms need to be filled out in every single case having to do with custody. And it's also included in our final judgment packets if child custody is involved. Skip to some other slides. So for definition, the big words in custody is legal and physical custody. So legal custody has to do with which parent, or do both parents have a right to make decisions regarding the health, welfare, education, and religion of the child. So legal custody you can think of as like the big picture thing, like which parent, or do both parents get to make decisions about, the big picture things. In California, it has been my experience, and especially here in Orange County, that outside of something, pretty significant, most judges' default is that the parents will have joint legal custody. Again, there's always exceptions to the rule. For example, if there's a domestic violence restraining order against a party, then there's actually a presumption against the fact that parents should have joint legal custody if one party committed domestic violence against the other party or the children. And in that case, sole legal custody usually is given to the non-abusing spouse. But in practical practice and, pursuant to the law, the default usually is joint legal custody, meaning one parent can't decide, hey, you know what, I'm practicing X religion, and another, party is practicing Y religion. One parent can't decide to unilaterally say, okay, this child is now only going to practice Y religion. That is a decision that both the parents have to make. And if they can't come to a decision, ultimately that will go to a court. There are times when the court will kind of, split the baby and say, okay, well, mom can have sole legal custody as it relates to health. Dad can have sole legal custody as it relates to education. Meaning if dad wants to send the child, to a school, let's say you live in a school district where you can kind of pick whatever school you want to go to. The court can say, okay, dad, you have sole right to do whatever you want. Mom can't say boo about it. Same for religion. The court may say, okay, in this instance, we're going to give mom the right to make whatever legal decision she wants about, religion. I have found that to be more the exception than the rule when the court kind of gives one parent sole legal over some specific area. But it is, I would say 90% of my cases, the parents are going to get joint legal custody. Physical custody literally relates to who has physical custody of the time. I find that the new way to describe physical custody is more like visitation or parenting time. All these terms are kind of used interchangeably, and there's always a new word for the day. Physical custody can be important in cases of like move away. So the parent who has more physical custody time, courts are more likely to allow that parent to move away from their current location. So let's say mom has what's called primary physical custody. So more physical custody than dad. Depending on the situation, and there are whole other factors, that's a whole different area of the law. But the party who has more physical custody of the child or children will usually be given a little bit more leeway to be able to move. So if mom says, hey, I'm living in Orange County, but it's gotten prohibitively expensive, she doesn't even have to give a reason. But let's say I found a job in, Las Vegas. It's much less expensive to live there. I already have a job secured. I want to be able to move, because in most instances, you can't just pick up the child and move, because again, there's going to be joint legal custody and some sort of rights to the other parent. So physical custody can be important in certain situations, but again, the terms most people are starting to use now, probably more, parenting time, visitation, physical custody is important, but in the end, it's just a matter of how much parenting time one parent has versus the other parent. And that may be equal. I know sometimes people will say like joint physical custody, and that doesn't necessarily mean it's 50-50. Some people throw the term around like primary physical custody, sole physical custody, meaning, and usually when you hear sole physical custody, that usually means really the other parent has little to no parenting time, meaning that parent really doesn't see the child or children at all. So, yeah, this is slide 20, just a definition of physical custody. You'll find that in the slide 20. 21, this is a joint and sole custody, sole physical custody resides with and is supervised while one parent visits. Again, everyone uses these terms a little differently. I know some people use the term sole physical custody to mean literally there's no visitation. It doesn't mean that there can't be, but I find these terms to be pretty fluid and they do change over time. Again, my own experience is that most practitioners are now using parenting time or visitation time. So the right to make decisions regarding child's residence, health, education, welfare is shared by both parents if it's an award of joint legal custody. So again, I've had experiences where judges will say, okay, dad gets to take care of education, mom gets to take care of health, but 90% of my cases, again, outside of some sort of weird circumstance, it's going to be joint legal custody. That's usually the default position for most judges. Not all, but most judges. Okay. Again, just more definitions on slide 23. And this is important. An absolutely equal division of the child's time with each parent is not required under joint physical custody. That is absolutely true. Another term that is used by most practitioners is this frequent and continuing contact. That is used all the time. So, practitioners will say, well, Your Honor, father should be able to have frequent and continuing contact. In my opinion, that's a very vague term. What I may consider frequent and continuing versus what the other party may think is frequent and continuing versus what the judge may think, it's very subjective, which is why I think, child custody can be very difficult. Understandably, most judges, in my opinion, don't necessarily want to spend a lot of time in family law. They get to rotate into different divisions, civil, probate, criminal. We have a lot of turnover here in Orange County. I think that's pretty much the case in any other jurisdiction. So when you have a lot of new judges coming in, and if they've had no background in family law, it's very hard, I think, to get the newer judges to understand what frequent and continuing contact means. And every judge comes in with his or her own perspective and his and her own life experiences. So even though we say frequent and continuing, again, these words are so vague, at least in my opinion, they're so vague. It really isn't a bright line test where they say, okay, frequent and continuing means you have to have, 3 hours a day or at least 1 hour every 3 days. It's nothing like that. It really is subjective. So it makes it hard, to say, well, I think this is frequent and continuing, which means every other day or a pure 50-50 plan where some parent sees the child every 2 days and then you flip weekends, or is it a week on, week off, versus some judges I know think that frequent and continuing contact may mean every other weekend. And, a lot of parents may disagree with that. I can tell you here in Orange County, I believe most judges, and we do have a lot of newer judges, but I think the trend is, for the most part, again, outside of something really significant, most of the judges are looking at somewhat of a pretty equal timeshare, so like a 50-50 timeshare, and that can be devised in many different ways. Again, week on, week off. I have some clients who literally do day on, day off, which I don't think is great for the kids, but if it works for them, great. They have what's called a 2-2-5 schedule where, one parent spends Monday, Tuesday with the child, the other parent Wednesday, Thursday, and then they switch the weekends. There's all different ways you can, get to what's called a pure 50-50. And I think most of the judges here in Orange County prefer what's called a 2-2-5, where one parent gets Monday, Tuesday, Wednesday, Thursday, and then you flip the weekend. It wasn't always that way, but I see it trending more towards a 50-50. If one parent wants it and the other parent can't really give a good explanation as to why, most of the judges here in Orange County will go ultimately for, that 50-50 timeshare. Again, they're talking about the frequent and continuing contact. That is a big buzzword in the family law code. But again, I think that is up to interpretation by a lot of different people. And I don't know that it's necessarily helpful to say that something is frequent and continuing contact. That ultimately ends up being, as paralegals, or paraprofessionals, helping your attorneys draft the appropriate, memorandum of points and authorities or the appropriate RFO, and get the facts from the clients to say, why you think this is frequent and continuing contact. Or if you all decide to go and practice law, become a practicing attorney, then to go into court and say, hey, we're arguing this. This is why we think this is frequent and continuing, and not what the other party is suggesting is frequent and continuing. So again, want to just kind of go over mediation and conciliation. It is mandatory, which is kind of an oxymoron, because mediation, usually outside of child custody mediation, requires, it's a non-binding process that the parties have to agree to participate in. It's an alternative dispute resolution. But in the context of family law and family court services and child custody, mediation is required. Some judges are very, very strict with this, even if parties go through private mediation and they've said they've tried to discuss it, but it's not going to work out. They're going to make you go through the court-ordered mediation before the judge will even consider your case. So again, if for some reason one person or the other party didn't come, you get to your court date and you say, geez, judge, we didn't go. What they'll do is they'll just continue your matter and they'll make you go to mediation, and then they'll just kick your case until both or one of them go. So it is absolutely mandatory. And again, Orange County is a non-reporting, which makes it good and bad. Because obviously if you are in a reporting county and that report comes out favorable to your client, it's great. But if it's a non-reporting, you're just basically, the mediator will either say, yes, they made an agreement, here's the agreement. And even with that, I mean, the judges don't like this, but even if the parties were to go to mediation and let's say they did come to an agreement, they can come to court and say, you know what, I didn't know what I was signing. I don't agree to this anymore. Depending on the judge, some judges will say essentially, so sad, too bad, you signed this. We're not going to go through this. You can't come now and say you don't want to, agree to this. Some judges are more lenient and will say, okay, well, then we'll set it for a hearing and then you guys can argue whatever you want. So that also depends on the personality of the judge and who you're assigned to, and even within different counties, that's going to be totally different as well. So temporary custody awards and modifications. Oh, I think I already did this one. Okay, so temporary custody awards and modification. So for temporary awards, they are going to look for quote unquote, what's the status quo? What has the child essentially, if there's an existing parenting plan in place. So for example, let's say for whatever reason, the parents have separated for a while, they just didn't file any sort of divorce proceedings or an RFO for custody, but they've been able to have a week on, week off schedule. And then let's say then you file 2 years later, and then one parent says, well, you know what, I don't like this week on, week off. I want to do a 2-2-3 schedule now. The courts are going to kind of look at, okay, what has been happening in the recent past? And they are really looking not to disrupt the child's life. You will hear judges frequently say, hey, you two are adults, you can fight and do whatever you want, but we are really going to try to safeguard the children, and they're going through a hard time as it is. We want to try to make their lives as easy as possible. Too bad that you guys aren't getting along, but we're not going to disrupt the children's lives. So if they've already been, exercising some sort of visitation plan with some amount of regularity, it's very rare that the court is going to disrupt that outside of something, very, very significant. They're going to try to keep the status quo. If there's been no status quo, and let's say the parties have been living together and then they file and then one party leaves, there is no real status quo. So at that point, they'll try to, come up with a visitation schedule. There's also step-up visitation. So if the child is more bonded with one parent, but then the other parent moves out, they may slowly try to, get up to a point of 50-50, depending on the age of the children as well. If there's a very, very young child, I've had many cases where they're, babies. Judges can be that can be an interesting situation. Some judges take the position like, hey, especially if mothers are, breastfeeding, they're not going to really necessarily want to have, 50-50. It's just not feasible. But I've actually had some judges say, hey, you're going to have to pump and we're going to make it 50-50. So again, it just really is based on the judge's lived experiences and how they feel about certain matters, which is another part of the frustrating part of family law, because even within the same county, you can have judges have very, very different opinions as to how they're going to fashion a visitation plan or a parenting plan because, again, based on their own lived experiences. Okay. Gosh, I took more time on this, but this is such an important area of the law. I just want to kind of go through what I figured are the highlights. I know, and if you haven't read it yet, I totally understand, but do any of you guys have any questions about what you read or anything about child custody that I can answer? Because again, this is really important. I think if you guys end up being paraprofessionals for a family law firm or even go work for the courts, you are going to run into a lot of child custody issues. So does anybody have any
Yes.
questions about this?
Yes, Professor Jesse Lopez here.
Hi,
Hi.
Jesse.
You were talking about the 730 evaluations.
Uh-huh.
Is there any material out there, maybe on the court website, that explains the process? or law related to that?
You know what? I don't know if Orange County, they may, and I will put it on the announcements. And if
Okay.
not, I will find something that like kind of goes into details about the 730 custody evaluations. I'm also going to put up on the announcements. There's also other types of evaluations. There's a Family Code 3111 evaluation, which is much more truncated, and you can kind of check off what you want these evaluators to review. And those are, unlike 730, which is a private evaluator, the 3111 investigations are done through Family Court Services as well. And sometimes they'll do that on an emergency basis, because let's say somebody comes in and says, oh my gosh, you know, my soon-to-be ex-spouse is literally engaging in some sort of sexual inappropriateness with their child. The court will usually at that point do, you know, order an emergency investigation to be conducted, because obviously those are very, very serious allegations. Or if one party is saying, hey, this party is literally consuming, you know, substances while they are taking care of the child, that will usually trigger a 311 evaluation as well. So I will put up, Jesse and everybody, resources and information regarding the 730 custody, which again is private. Those are people who don't work for the courts, as well as the 3111 investigations. And then I know I don't know if LA is still doing this. They used to, and it may have been just through COVID, but they had a really interesting like PPI 1 and PPI 2 program where it was almost like a 3111 investigation, but they did like half a day or 2 day. I haven't really heard that brought up again since COVID. But I'll try to put up as much as I can. Each
I
county
have
has
a question.
as well. Yes.
And I'm sorry for the background noise. I'm I'm actually moving, but anyway, I have a question regarding the terminology about the difference between custody versus responsibility. So there's financial responsibility, which is sort of like child support, and then there's custody, which is the right to be able to be with them. Now, if you had financial responsibility, meaning child support, there's also making decisions with regard to the child's estate. So, for example, if the child has an inheritance that is going to happen later on, who has power and control over that as a parent? What is that power, that thing called?
Well, it's so, for example, like I have a lot of clients who have opened up accounts for their children.
Uh-huh.
So usually one parent is tasked with basically safeguarding that asset on the benefit for the benefit of the child. I mean, there's other vehicles available, but for example, even for like a college savings or something else, or let's say there is an inheritance and, you know, mom or dad has set up a separate account, it may not even be in the child's name. You can tell to the court, hey, listen, this is for the benefit of the child. I want to act as essentially the custodian for my child and be able to manage and take care of this
So
account.
it's called custodian rights.
Right, basically. And if it's under your, so unless it's under the child's name for the benefit of, or the child's name is not somehow tethered on there, what the court will do is we'll consider that a community asset, and then we'll assign it to one parent or the other, but for
Okay.
the benefit of that child or children.
Okay. Thank you.
Of course, of course. Any other questions? And if not, we'll take a 10-minute comfort break. And again, please feel free to reach out to me. You guys are doing a great job of emailing me and going through Canvas. But any questions regarding custody at this point? Perfect. Okay, then let's take a 10-minute break and then we'll jump into visitation. Thank you, everyone. everyone. Hang on, what's going on with my sharing? Hang on. Okay. Do you guys see my screen?
Yes.
Yes, we do.
Says child visitation.
Introduction.
Okay, yeah, it's not the right screen. Hang on for 1 sec. Do you guys see child visitation on the screen?
Yes.
Yes, perfect. Okay. All right, guys, so let's go on to child visitation. So they are referencing a code section, Family Code 3100, which mandates that whenever there is a custody order, the court shall grant reasonable visitation rights to a parent when it is shown that the visitation will be in the best interest of the child. So again, there's that term, best interest of the child. I have found that most courts and most judges find that, visitation with the parent is important, and that's always going to be in the best interest of the child to have some sort of visitation, whether that is, 50%, less than 50%, more than 50%. That doesn't so much matter other than there's some sort of contact with the other parent. So assuming that the visitation is not detrimental, courts will allow non-custodial parent a visitation schedule that is reasonable. So again, outside of a court finding that a parent has committed domestic violence against that other parent or the child, they are going to find that the visitation is reasonable. Okay. Visitation plans. Again, frequent and continuing. The textbook says the ideal is 50-50, but sometimes, sometimes it's hard for parties to exercise a 50-50 timeshare. If the parties get along, and one party maybe has a full-time job and the other party doesn't have a full-time job, they'll use the party who doesn't have the full-time job almost as like daycare, because some parties feel like, hey, it's better for the parent to take care of the child than to have the child go into daycare. So again, if the parties agree to a timeshare, great. I know, especially my clients, they don't necessarily agree that 50-50 is ideal for a variety of reasons. So the caveat here is, to the extent that such a split would interfere with the child's development or schooling or provide similar obstacles, the goal of a 50-50 split is not artificially imposed for the sake of achieving mathematical equality. And that is absolutely true. Because again, unless the parents live close to one another, it may not be possible to have 50-50. So again, if somebody lives in Southern California and then another parent for whatever lives in Northern California, it may not be possible to have a 50-50, because obviously the child is going to have to go to school in some school district. And in that case, you're not splitting the week up, half in Northern California and then half in Southern California. Visitation plans. I know the textbook brings up this Freeman plan. Frankly, this is the first time I've heard of a Freeman plan. I know what the 20% non-custodial parent is. So back in the day when, I was first starting out, I think there was still a little bit of this where the fathers maybe had less time than mothers did. I think that's changed significantly even since I've been practicing, and I've been practicing for a long time. But I think definitely the courts, judges, public policy is going more towards the 50-50. But when I first started, I guess how they're describing it as a Freeman plan, it was usually like an 80-20 split. So if, in most instances, again, if it was a father who was working full time, and let's say they had parties had a traditional relationship where, women didn't work and the fathers worked, and then they got a divorce, what they're identifying as a Freeman plan, or the 20% plan, would be where father would exercise timeshare with the children every other weekend. And that ends up being, the 20% timeshare. And again, even through my practice, that it's very rare in my practice that one parent is only going to get 20%. I think for the most part, parties are closer to 50-50. It may not be exactly 50-50, but more towards 50-50 than a 20%, 20 to 80% timeshare. And again, that completely is dependent on each party's perspective. I know culturally, I'm from Korea, and culturally Korean, which seemed it was news to me when I first started practicing and I had Korean clients. But in Korea, I came to find out that it's the fathers who usually actually have more timeshare than the mothers. Jesse, did you have a question? Jesse?
Yes, yes,
Oh,
Professor.
did you have a question? Yes.
Uh, yeah, I was wondering right now, how are courts handling situations where one parent is a working parent and the other is like a stay-at-home? Do they give, more preference nowadays to parents that stay at home versus the one that's working? Or is it close to 50-50, like you're saying?
I think it really depends on a variety of factors, including if one of the parents wants 50-50, and also the age of the children.
Mhm.
Um, let's say, for example, it's the mom who works full time, and dad can take care of the kids. Um, Depending on the nature of their relationship as well. I mean, I do have a lot of clients who will say, I don't care. I'd rather put my child in daycare because it is so acrimonious. I cannot get along with the other parent. I don't want that child in the other parents' care while I'm working. I need to work. So I'm allowed to work, and I shouldn't be penalized that I work. I still want my 50-50. And it's been my experience, again, outside of some sort of allegation of abuse or something significant, even if you are working full time. And frankly, in most instances, both parties are working full time at this point. I very rarely run into a situation where one party or the other is just not working at all. Usually there's just both of them are working. The courts are going to go towards 50-50 and say, that's fine. I understand you may not be working, but each party has a right to 50%. And that party, even though you're not physically seeing your child, you can put that child or children into daycare. During your custodial time. And if the children are in school, it usually means, they go into aftercare for a couple of hours, and then the parent comes and, takes care of them at night, puts them to bed, and all these other things. But I think a lot of that is also dependent on the age.
Oh,
And then,
okay, great.
yeah. And then once, here's the other thing. Once kids turn 14, and I believe we went over this in another section, they get to voice where they want to be. And for all practical purposes, once they turn that age, no court, at least in my experience, is going to force a child over 14 to go back every other day, every other week. At that point, the children are pretty much doing whatever it is that they want to do. And judges will literally look at the litigants and say, what the heck do you want me to do with a 14, 15, 16, 17-year-old child? I'm not going to be able to force that child to go with you, even if there's like a 50% timeshare, right? I mean, at that point, they're so old. Police very rarely get involved. I have had certain instances where the police will try to, extract the child, but usually they take a hands-off approach, like, hey, this is a family matter. We're not going to get involved. If your child doesn't want to go, your child's not going to go. But I have seen, especially in Orange County, most of the judges really do push for a 50-50, regardless of the circumstances outside of like restraining orders or abuse allegations or something of that nature.
Professor, are there any instances to where the child may be able to make that decision earlier, like at the age of 12 or 13?
So
Or
the court,
14?
so by law at 14, the courts have to consider the child's wishes. At any time, even before, the courts have the discretion to take into consideration. And some children at 12 are more mature than a child at 17. So yes, the courts can consider the child's wishes, and they'll take a global approach. The reason 14 is important is because once they hit 14, the court has to consider it. Now, listen, even though that's the law, we had a judge here in Orange County. He's now off the family law bench, but he would routinely say, I don't care how old your child is, I'm not going to talk to him and her or her. The children don't get to make decisions. You're the parents, I'm the judge. I don't care what your child says. So, again, that's, in my opinion, the frustrating part of family law. There are clear things, the law is there, the law, as much as fluid as it is in family law. And there are judges who will literally say, I don't care. I mean, they'll do it and they'll go through the steps, but ultimately their position is, we're the adults. You don't let a 14-year-old child, 15-year-old child, 16-year-old child make a decision regarding what he or she is going to do. But to answer your question more directly, the court can consider it, but they don't have to, nor are they required to under the code.
Okay, thank you.
Of course, of course. Okay, so the visitation restrictions, says variety of circumstances in which restrictions can and should be placed on visitation, ranging from financial misconduct to domestic violence. The party seeking to restrict visitation bears the burden of proof. So that is true. So if you're the person saying, hey, I don't want this party to have any visitation, that party has to go to court and say, why should we not allow the other parent to have some sort of visitation with the child? It'll become your burden or your client's burden to show the judge, hey, this is why I don't want, mom or dad to have any sort of visitation with the child. And again, very rarely outside of abuse allegations, restraining order allegations, have I seen a court say, no, we're just not going to give, the other parent any sort of visitation. That's just, I've never seen that happen. Interference with custody and visitation. So if the child is a teenager or possesses other actual physical impediment to the custodial parent's ability to exercise sufficient control over the child to ensure that visitation proceeds as scheduled, then the custodial parent will generally not be held accountable for that child's failure and refusal to visit. Again, so this is, an older child's refusal. So let's say you have a 16, 17-year-old child who says, listen, I'm just not going to go to mom's or dad's anymore, and you can't force me to. That is absolutely true. These situations come up when, a party can file what's called a contempt action saying, hey, I'm supposed to see our child, Monday from 5 to 10. And that child refuses to visit. So then that parent goes into court for contempt, meaning, hey, other parent, you are refusing visitation. I'm supposed to see our child on Monday between 5 and 10. So they'll file a contempt action and say, hey, judge, make the other parent, bring the child to the visitation. Again, in my experience in Orange County, after a certain age, the courts are going to say, listen, number one, the child's too old. You can't force a child to do it, as long as the other parent isn't actively, literally blocking the door and trying to prevent the child. If it's a child's decision, there's very little a court's going to do, and they'll have very frank discussions with the parties I've certainly been in court where the judges will look at the parties and say, what is it that you want me to do? This is practically an adult. I can't force a child to go with you, and I'm not going to make any sort of contempt orders, because it's not as if the other parent is literally trying to prevent the visitation from happening. So that's with the older children. So the slide says if they're younger, then the court takes a position for like a 2 to 3-year-old. You have essentially complete control over that child. And if the court starts to find that, one parent is constantly finding reasons why they can't bring the child to the visitation, that can be considered interference with custody and visitation. And there are judges here in Orange County, if they find a pattern of one parent essentially prohibiting the child from visiting with the other parent, they can completely switch it. And they will say so in court, like, hey, if I find that you are deliberately keeping the child away from mom or dad, and the child is 2, 3, 4, 5, a young age, then we're going to give primary physical custody or most of the physical custody to the other parent, because we do not want you to frustrate the other parent's ability to have a relationship with the parent. For the most part, courts think that is very, very important for the child to maintain a relationship with both parents. And again, always exceptions to the rule. If they find that one parent is committing domestic violence, or there's sexual allegations, or there's substance abuse allegations, of course, they're not going to say that that's in the best interest of a child for that child to have visitation with a parent. I think this is what we're talking about. So a custodial parent who refuses visitation when the child is otherwise inclined to visit runs a serious risk of losing custody. That is true. I have seen that actually happen in court. Luckily, it wasn't my case, but from what I could tell, the parties have been coming back to this judge over and over and over again. The judge had his fill, and like right before my eyes and then before the gallery's eyes, took visitation away from mom, ordered the children to be put into dad's custody that very day. I mean, it was horrific, just a lot of screaming with the kids, the parents. But at some point, if the judge thinks one parent is withholding visitation, they absolutely have a right to just switch it around. Even though that's an option, I certainly haven't had that happen in my practice, but I have seen it in real life where it will switch. I just don't see it happening that much. But again, depending on how egregious the situation is and how far a parent takes it, this is absolutely a possibility. So it's important as paraprofessionals, or if you guys decide to practice law at some point, you tell your clients, hey, listen, if you're playing games and you're making up reasons not to allow your child to visit with the other parent, there is absolutely a potential for that judge to completely give that child to the other parent. It absolutely can happen. Okay, so relocation. Relocation comes up frequently. These are considered quote unquote move away cases. As it says here, the court will require the parent to give a minimum amount of notice. That's usually 45 days. Move away usually means when, there's no set like mileage, but in my opinion, once a parent moves far away enough, definitely if it's out of the county, or if it changes the school district, if both parents at one point living in the same school district or in the same town, I don't really consider that a move away. But once it goes into a different county, or the children would be going to a different school, and obviously if it's across the country or a different state, that would be considered a move away. My experience has been in most move away cases here in Orange County, the judges will require at least some sort of custody evaluation so that the evaluator can meet with the children and the parents, especially depending on the parenting time each parent has currently, so that the 7:30 custody evaluator can essentially give a report to the court, because then they take care of interviewing the children and the parents and saying, okay, based on my interviews with the parents and the kids, we think this will be fine. The kids will be able to adjust whatever the situation is. So that's been my experience especially in more contentious moveaways. If somebody's really fighting it, the judges usually will order some sort of 7:30 custody evaluation at that point. So it says the rule in this area is now quite clear. The focus must be on the child, not the parents. That is true. Not the motivation for their move, not their good faith or bad faith. That is also true. The courts will not say, oh, you're doing this just to try to keep one parent away from the other. I mean, in most instances, and in my practice, my move away cases has usually been because, one parent can't afford to stay in Orange County, especially in divorce cases. It's, very expensive to live here. So they have to move, or they don't have family here after the divorce and they want to be closer to family to be able to live there. I myself in my own practice have never run into a situation where a parent is trying to move just to thwart, visitation with the other parent. It's usually for very legitimate, good faith reasons. Court recognizes that the burden of proof is on the parent who opposes the relocation to show that the move is not in the child's best interest, but they also granted the trial court's great discretion in its ultimate ruling. The moving party need not prove necessity for the move, but the focus remains on the child. That is true. So the older the child, the more contacts he has with the community. So let's say, for example, the parent who wants to move away, they've lived in Orange County their entire life. The child has been going to the same school and has, friends, maybe even goes to the church in the community, and they have a very strong basic, they're tethered to the community and they're 14. It's probably going to be harder in that case versus a younger child because they haven't set their roots down in that community. And especially if the parent who's not moving away opposes it and they have more, closely to a 50-50 timeshare, and that child can stay in that school district with a non-move away, that's probably going to be harder for the move away client to say, I want to take the child with me. So don't forget, this doesn't prohibit a parent from moving. It just prohibits the parent who wants to move away to move with the child. And obviously, depending on the distance of the move, frequent and continuing visitation may not be possible. So in cases where a parent moves, across the country, usually those visitation schedules are switched so that the parent who's moving away will get more, vacation time, summer vacations, and things of that nature. But the more ties and the older the child is, in my experience, it's been harder to have the court grant a move away and have that child move away with that parent who wants to move away. Okay, so remedies for frustration of visitation. There are a variety of remedies. I touched on this. The non-custodial parent can commence an order to show cause in an attempt to have the court levy monetary penalty against the custodial parent or imprison her for violating the court's orders. So we talked about the RFO. OSC is an order to show cause. So anytime a person violates an existing court order, that party has an option of filing what's called an OSC, an order to show cause. File that and have the person come to explain why that person is not following the orders. So an OSC for contempt means the person is in contempt of court orders, meaning they're not following the court orders. So they can say, hey, father is not allowing child to visit with mom, the court said, you know, the child can visit with mom on X days during this time. Father's not allowing it. So court, I'm bringing this OSC rate contempt for you to essentially levy financial, monetary remedies, and in other instances, it's quasi criminal. So some judges really do not like OSC rate contempts in family law because it is quasi criminal. You do have to be arraigned. You have to have your, rights explained to you. And for a while there, they just really didn't like to hear OSC contempts, and it was pretty much routinely dismissed. But in the instances where it does work, there is a potential for jail time. I had one case, and I was not expecting this because, again, for a long time, family law judges really just did not like to deal with contempts. But I have filed a contempt against a father because he kept violating the permanent restraining orders. And this was a newer judge, and she literally had him handcuffed because he was found guilty of the contempt, and he was handcuffed and taken into custody that day. And again, that really rarely happens in family law cases. I've been in another case, not my case, but in the gallery, and the judge in that case also put the person who was found in contempt in custody, and then he was taken away. But again, very rare, but it is quasi-criminal, and you can get the person put in jail. In most cases, the most judges will do is maybe do basically community pickup. So they'll be on the side of the road picking up trash. That's usually as harsh as they used to get, but I've been seeing more and more they are willing to use the heavy hand of actually putting them in custody if you have been found to be in contempt. So the non-custodial parent can also ask the court to post a monetary bond to secure performance and compliance with the visitation orders. So they can say, hey, make him post a $25,000. That's an example, to ensure that that party is going to comply with the custodial orders. Such a request is generally not granted the first time. Again, I find that to be true. Most judges, in my opinion and experience, loathe these OSC rate contempts because they don't really think that it's appropriate to have a criminal element in family law. I think they just think it incenses and makes things more litigious, and they try to stay away with it. Usually the non-custodial parent must demonstrate a history of frustration. That is true. So if there's just been one instance, most courts are going to say, come on, don't waste the court's time. If a party is 10 minutes late or they miss one visitation, they're probably not going to look at that very favorably. But if it's been a repeated violation, like literally every single visitation, the parent and the child don't show up, and it's been going over 2 to 3 months, the court is going to take that into consideration. But yeah, if it's just a first-time offense, the court's probably going to be angrier at the person who's bringing the OSC rate contempt because, again, they want people to get along. The judges will routinely say, listen, you're going to be parents to this child even after 18. You guys need to try to work it out and get along. You guys are both adults. Unjustified interference, no matter how deliberate or malicious, will not excuse withholding of child support. Absolutely true. Child support and visitation, two separate things. One doesn't beget the other. Visitation interference is not a defense to an action for non-payment of child support. Again, true. The courts are always going to say that parents have a financial responsibility for their children. I think this is also especially true because they do not necessarily want the child to become a public charge or have to, go on some sort of assistance in order to satisfy the obligation of a parent who should be taking care of their children financially. Parents whose visitation is being frustrated have various remedies, including civil lawsuit for emotional distress, lawsuit charging interference with relationship and other torts. I don't do a lot of civil. I did start out in civil. My experience has been, especially in Orange County, I haven't found that emotional distress or like personal injury suits are that well taken, especially in Orange County. I think the Orange County juries tend to be a lot more conservative. So I don't know necessarily in Orange County if this would be the best remedy. I think the best remedy would still be to go into the family law court and continue to demonstrate, hey, these are the things that this other parent is doing. And at some point, the courts and the judges do get it. If the other parent continues to do bad things and continues to frustrate the visitation, again, maybe not the first, second, third time, but a lot of family law is just grit and going back again and again and again until the judges finally understand it. I don't think I'd ever recommend for my own clients to try to file a civil lawsuit, because then you're dealing with a civil lawsuit as well as your family case, and I think that just gets to be too overwhelming and stressful. So sometimes it is the other way around, in that the non-custodial parent refuses to visit the child. Yes, I mean there are sad cases where parents don't seem to care, and a way of taking care of that is at some point you just go into court and say, hey, the court, you were generous, you gave father or mother X amount of time, they're not exercising any of this time, and just get the custodial orders changed so that the party taking care of the child just gets sole physical custody at that point. Harsh reality of the situation is that if the non-custodial parent truly wants nothing to do with a minor child, then he simply is not going to visit. Absolutely true. So the only thing you can do at that point, I mean, if you are the parent that is taking on all the responsibilities of taking care of the child, hopefully the other parent has some financial resources, and child support should be adjusted accordingly. So if you're taking care of the child more, presumably you should be getting more child support because you're taking on the financial burden of taking care of that child as well. So I have had a couple of sad cases. Those cases always make me, it breaks my heart when a parent just refuses to exercise visitation with their child. Non-parent access to children. So this deals more with grandparents' rights. And this appears to be a U.S. case, and they're also talking about a Washington statute. For the most part, just generally speaking with law, and especially in family law, since this is a state court issue, we don't usually cite to federal cases or cases outside of California, because again, especially in family law, California is so unique and distinct in and of itself, meaning our laws are usually different than the other laws, especially because we're a community property state. I believe Washington is a community property state as well, but I know because I have a case where my client entered into a premarital agreement in Washington, and we're trying to decide which laws prevail. So Washington State, even though it's a community property, it's still a little different. Okay, so they're talking about the U.S. Supreme Court case. It says Troxel involved the right of a natural parent to keep everybody else out of the affairs of his children. It did not involve a constitutional right on the part of a grandparent to visit with the child. U.S. Supreme Court found significant problems with the Washington statute. It was overbroad. It authorized any person at any time to petition for visitation. I've had cases with grandparent visitation and step-parent visitation. I think those are usually the visitation rights that are sought by individuals other than the parents. I haven't had any instances where anyone other than step-parents or grandparents have tried to have visitation exercise with the children. So post-Troxel, again, U.S. Supreme Court case, any statute that creates a right adverse to the desires of the parents will probably need to include elements to survive constitutional challenge. It says C-151. I don't know if I put that in the reading, but I'll definitely put that into the announcements if I haven't. In light of Troxel, California courts found that 2 California non-parent visitation statutes bear similarities to the Washington statute at issue in Troxel. So I will post 152 if I haven't already. So they're referencing Family Code 3130. It is stating that it has not yet been found unconstitutional by the U.S. Supreme Court. But again, people are litigious and it may come up at some point. But again, I think in most instances, my experience has been grandparents as well as step-parents. So the Family Code sections 3101 through 3105 cover visitations for step-parents, grandparents, and legal guardians. These individuals have the opportunity and right only to request visitation, and nothing in the code mandates that such visitation be provided. As with virtually all other determinations, the primary inquiry will focus on the best interests of the child. So in my cases, dealing with grandparents and step-parents, a lot of the focus on the court's analysis will be looking into the relationship that grandparents or step-parents had with this child before they file for the request for visitation. So if grandparents have, let's say, somehow been the primary caretakers, or the step-parents have been step-parents since birth and have been in that child's life, then the courts will usually grant some sort of visitation. But if they had very little contact, I had a case where the grandparents essentially, so it was paternal grandparents, father passed away, and the grandparents wanted to have visitation with the grandkids, but prior to this time, they really had no relationship with the grandchildren. And my client's allegation was that they were just wanting to exercise visitation because they never really liked my client and to kind of make her life miserable. That was her position. And when the case finally went to trial, the court found my client's reasoning to be credible, meaning grandparents had never shown any interest in the grandchildren before, had maybe 1 or 2 visits in their lives, and they did not grant visitation because, again, my client was the natural parent, and the court believed my client in saying, hey, they're only doing this because they never liked me before the marriage and they're just trying to interfere with my relationship with my children. Yolanda, you had a question. Let me get through this because I think I'm pretty much almost done, and then, yeah, let me just get through this. But I see your question. Okay. Subject of non-parent visitation can be divided into grandparents, step-parents, and non-parents. So those are basically the 3 basic areas. Family code and cases cited thereunder provide instruction in all 3 areas. So again, the 3101 to 3105, which is referenced in the prior slide, that's where those are going to be discussed. More specifically with grandparent visitation, Family Code 3103 provides that in any proceeding involving child custody, upon petition of the child's grandparents, the court may grant them reasonable visitation if it finds it's in the best interest of the child. If the child's parents agree not to grant visitation rights to the grandparents, and courts operate under the rebuttable presumption that grandparent visitation is not in the best interest. Meaning, if the parents don't think that visitation is appropriate, then it's up to the grandparents to say, why should we allow visitation? You have natural parents saying, hey, we're the natural parents or the adoptive parents of this child. We don't want grandparents to visit them. Then the burden shifts to the grandparents saying, you tell us why we should go basically against the parents' wishes and grant you visitation of the children. A step parent visitation, that's going to be found in Family Code 3101. Again, I'll put these pages in if they aren't already in there. My experience with step parent visitation, again, best interest of the child and depending on the relationship they've had with the child prior to their request for the visitation. I have found in instances where the step parent has been an active part of the child's life, most parties, again, unless it's completely acrimonious and nobody likes each other and everybody's at each other's throats, in most instances, they will come to an agreement and allow the step parent to have visitation by agreement. So again, a lot of the textbook deals with what happens if you go to court, if you can't agree. I would say, although it seems to be getting less and less, and I don't know what's happening or what's in the air, most of my cases are now going to trial, which is not necessarily a good thing. But, you know, there are instances where people can come to an agreement. And in most instances, when parties do come to an agreement, the judges are not second guessing the party's agreement. They're pretty much going to rubber stamp it. So if the parties all agree, hey, step parent visitation is appropriate here, and it's put into the judgment, the judge is not going to question you and say, hey, why did you put this in here? They're just going to say, okay, that's fine. And they're going to rubber stamp it, and you're going to get a judgment with step parent visitation or grandparent visitation or third party visitation. Okay, so other visitation, that's going to be in Family Code 3102 as a quote unquote catch-all, addressing everybody else who desired, but nevertheless might not be entitled to visitation. And again, I'll put in the actual pages. It should already be in the reading material, but I'll highlight it and make sure that it's in there. So they're talking about Troxel again. Again, it has to be very, you know, with most statutes, they need to be narrowly tailored. It can't just be a free-for-all. California is always going to look for the best interest of the child. As you see with the grandparent, they're going to look at the rebuttable presumption of a grandparent telling the court why they should have visitation, especially if the natural parents or adoptive parents do not want that visitation to occur. Okay, so I am looking at some questions. Let's see. Deandra, I'll respond to your question directly. Is that okay, Delandria?
Oh yeah, I'm great.
Okay, perfect. So I'll answer it directly. Okay. And then Jesse, with grandparent or step parent visitation, will that also subject them to child support? That is a really good question. I've never run into that. I'm going to say from my gut, no, but I will find out the answer for you. I don't think the visitation, because at least in my practice, it's not like grandparents or step parents have something like a 2-2-3 visitation. It's usually very limited. With my grandparent cases, they've been wanting like a week on or week off, or to take the grandchildren, you know, on a vacation or something like that. So that is a great question. I don't know the answer to that. I will find out for you though, and put it in the announcement. Great. I can't wait either. Okay. I'll find out and let you know. Does anyone have any other questions? Okay, perfect, you guys. Okay, Jessica, I see your message. I will mark that you are here. I was, before I decided I could not go forward with the class last week, I was going to do a test this week just to kind of space it out. But since I wasn't here last week, I'm going to make the test for next week under the same guidelines as the first quiz that you took. So that will be available after next week's class. Again, thank you guys for being so patient with me. I've been getting your messages, and if you have any questions or if I don't respond right away, again, I try to look at the emails from the college every day by logging on, and they should be forwarding to my personal email as well, but sometimes I don't get it. So if you guys ever have any questions and you're not getting a response, please feel free to text me. It's on my it's on the front page, my text
Do
number.
we have any assignments besides just the test in reading?
No, it's just going to be the test in reading, and then okay, somebody said, what will the test cover? Modules 3 and 4. So the reading for module 3, I kind of, it's going to be more or less what I went over today. So 3 and 4, which is the custody and visitation.
And Professor, I don't know if I heard correctly, but when is that test going to take place?
Next week. So it'll be live after class next week.
Got it.
Okay.
All right,
Wonderful,
cool.
everyone.
Thank you.
Yes.
Thank you.
Well, thank you guys so much. And Delandra, I'll respond to your message directly.
Thank
You
you.
guys have
Thank
a
you, Professor. Good
wonderful-
night.
Okay,
Good
thank
night.
you guys.
Thank you.
Bye.
Thank you.
Thank you. Good night.
Bye.
Thank you
night.
so much.
Professor, what is the live testing? Hello?
Hi, I'm sorry, can you repeat that?
I apologize. What does a live test ensue? What does that mean? So you said live after the class?
Oh, I'm sorry. Like, I'm gonna post it after our last class. I should have chosen my words more carefully. Just like the last test, as soon as we log off, it'll be available for you to take, and you'll have a week to take it.
Oh, okay. Is there any parts that we need to focus on in particular?
You know, I'm probably going to get it from what I went over today. I know I put a lot more reading material in the modules, but I just don't think that's fair. So I'm going to probably get the test questions from what I went over today. So if you kind of look over the PowerPoint for module 3 and module 4, you'll be more than prepared.
Do you want us to be able to quote the codes?
No, I'm not into and this is all open book. So like I said, I don't find that to be helpful because you can go online and find everything. It's going to be more general, like concepts and things that I think are of more practical use that you guys are going to see if and once you go into a family law practice.
Okay, and when will we see the results of our last test?
It should be up. Is it not up?
I'll check
gosh.
mine
Okay.
other before class.
All right, let me, I have graded all the minutes, should have gone up. Excuse my technical difficulties. Let me check on that. I'm pretty sure all of you guys did awesome, but I will double check. It should be showing. That's my technical idiocy. So let me figure out what's going on.
All right, thank you, Professor. Good night.
Oh, thank you so much. You guys have a wonderful rest of the evening. Delandra, can you hear me? Do you want me to just respond to your chat, or I can just tell you right now? What would you prefer?
I can hear you.
Okay, so if there is a child support order from California, then what that person can do, okay, now the mom is living in a different state.
Hmm.
Okay, so then she should be able to what's called enter that support order in whatever. So let's say she's living in Nevada, then she should be able to enter that support order in Nevada, and then Nevada will start enforcing that order for that person. So you just enter that support order.
So basically, it'll be like a case with child support within California and then within district in Nevada. If that
Right.
makes sense.
Right. So, for example, like I'll have people who have like a support order or custody order in New York. And what I do is I
Mhm.
enter that order or judgment here in California. And then the California courts will start enforcing it because all states have to recognize and enforce the orders of other states. So, the one thing I'm not sure of is, let's say, whatever new state mom lives in.
Mhm.
Um, I don't know what enforcement remedies that specific state has for
Okay.
violation of support. I mean, here in California, if you open up the case with DCSS, they can start
Right.
putting levies. They will suspend your driver's license if you have like a general they'll go and do everything. They'll start,
Right.
doing stuff with
Okay.
passports. I'm assuming it's the same with every other state, but I don't know since I'm not licensed in any other state other than California.
Okay. And I have another question as well.
Of course.
Is California still doing contempt of court when it comes
Yeah.
down to like child support?
Yes, but like I said, I've found most judges just really don't like contempt actions. Orange County's probably the most favorable and even going forward and having it heard. But
Okay.
for example, in LA, they just look at you like you're the most awful person if you try to do that. And I'm like, but why is it here then? I mean, people are violating.
Right. Yeah. Because I heard
And
last
yeah,
I heard that Los Angeles County child support was no longer doing contempt when it came down to child support. But then I started hearing that they were, and they were telling people that because they didn't want to enforce it.
yeah. Okay, so if you're talking specifically, if you have an open DCSS case, if DCSS will file that contempt for you, gosh, I haven't seen DCSS file a contempt action for somebody in a very, very long time. So what you say makes sense, but I don't think that prohibits you, meaning the person who has that order, to
Right.
go in and file something or to retain an attorney or someone to try to assist you in getting that filed. I don't think there is an absolute prohibition saying, hey, you can't ever file one. You can't ever file a contempt for child support. I mean, I certainly have
Right.
here in Orange County, um, but again, judges just don't seem to like to do it, and I don't understand it. I'm like, well, then don't have this. Don't have it
Right.
available to people because people are violating orders left and right. What's the remedy? You're basically saying you can get away with it, which is super frustrating,
Exactly. Yeah.
right? So it's like, well, then
Yeah.
don't have
Makes
it available
sense.
to people. I'm sorry I sound so sharp, but it's
No,
crazy.
you're
Like,
completely
why
fine. It makes
yeah.
sense.
Yeah, it's so frustrating as a practitioner. But yeah, so yeah, you should be able to enter what's called a sister state judgment, get it enforced there, and then I mean, if push comes to shove, and I agree. I mean, support is so important. If the county won't do it for you, I don't think that prohibits you from just filing your own. And they should have self-help centers, and I mean,
Right.
there should be someone
And
available.
what was the name of that order again so I can look into it?
The contempt, OSC rate contempt.
Yes.
Yeah, it's literally called OSC rate contempt. I'm gonna put it in the chat so you can see it. OSC rate. Let me see if I can find the. Bear with me for a second. Let me stop the share so you don't look at all my stuff. I'm gonna hang on. I'll give you the actual form number. This is in California, right?
Yeah.
Okay, hang on for 1 sec, Delandria.
Mm-hmm.
Form numbers. Hang on. Order to show cause. Are you familiar and how to get the forms online? Like
Yes, I
literally?
am.
Okay, perfect. Okay, so the OSC rate contempt is FL 410. Let me just open it up right now and make sure. Yeah, I think I have to do an attachment for this too. FL 411. And then FL 411. On here. Oops. And if for whatever reason you can't access it, please just send me an email through Canvas or whatever, and I can
Okay.
actually just attach these forms for you. You know what? If you give me
Okay.
just a second and if you have
Mhm.
time, I can do it through the chat right now because my forms are open up.
Yes, I do have time.
Perfect. Okay, then let me just open these up for you and send you these. But I think if you go onto the court's website or the judicial council form, they're fillable. Mine is I have a specific form program.
Probably.
Yeah, so these
Probably.
are not going to be.
It doesn't matter. Sorry about that. That was my sister.
Oh, no worries.